All right, it's 12:30, actually a little past 12:30. We'll go ahead and call the Guam Public Defender Service Corporation Board of Trustees meeting for June 24th to order. Will the Administrative Director please call roll?
Yes, thank you, Your Honor. We get the Chairman, Chief Justice Robert Torres,
I'm present.
Vice Chairman, Presiding Judge Alberto Lamarena.
He will be joining us. He's not on yet.
Okay. Member Attorney Jackie Terlahi.
Present.
Member Donna Munya Kanata.
We see her on the screen.
Yeah, I think she's on mute still.
She's moving. She's muted.
Okay.
She's present.
Present.
Donna, you can hear us.
Can you guys hear me?
We can hear you now.
Yeah.
Okay.
Can you see
We
me?
can hear you. We can hear you.
Okay.
All right.
Okay. Member Dr. Christiana Whitman.
I'm present.
All right. We do have a quorum. 4 of the 5 members are present. Notice of the meeting was published at the Post and in the public notice portal of the PDSC. First item on the agenda is the approval of the minutes from the May 27th, 2025 regular meeting. I entertain a motion to approve those minutes.
Motion.
I move by
second.
Trustee Kanata, seconded by Trustee Whitman. All those in favor say aye.
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 There being no objection, those meeting minutes are duly approved. Under old business, update Mike on is Mike there?
Yes,
On the financial status?
Yes, thank you, Your Honor. PDSC and APD are both operating at 97%. PDSC has also received a May release of $78,612 for CLC, and as of today, the total received since October 2024 is $713,492. For the EJC, PDSC issued an invoice for May 2025 to DPHSS, and as of today has received the reimbursements up to April 2025. For stock 2022, the balance for this grant remains at $13,328, which is scheduled to expire at the end of the month. A final invoice will be issued for June 2025. For WestCare, PDSC issued an invoice for May 2025 and received the payment, which brings their account with us up to date as of today. Those are the financials for PDSC and APD.
All right, thank you. Any questions from them? All right, there being no questions, we'll now go to the next item, which is the report from the PDSC Executive Attorney.
TJ, I'll fill in for Steve. He's off island at this point.
Okay.
Ken, can you go up to the first slide, the June numbers?
Just for the record, it's John Morrison, who is the acting director, who will be making the report today.
Thank you for that, TJ. So you can see the numbers before you. I think the most significant one is probably cases opened and closed for the month of May. You can see we're at 88 cases open for that month, just about the same amount closed, 83. This is kind of right in the sweet spot. This is where we would expect to be from previous years. You can see 2 previous years are basically right on the money at 85 and 87. There's a little bit of an elevation in 2022, but I think that can probably be screened as there's a backlog of cases that were charged out right at either statute of limitations around COVID or when things became operational enough that things could proceed more in the normal course. So from my perspective, it's right on track with the numbers. 83 closed, that can be conflicts, cases that went to parole, cases that the probationer successfully completed probation, or there was a revocation, but no further action is needed by our office, so it ended up closed. So right on money, basically. Ken, can you go to the next one? This slide, I think, sort of speaks for itself. It's criminal cases by courtroom, and we're looking at the status of the defendant at this point as far as release is concerned. Are they detained? EM, personal recognizance, what's their release look like? There's a smattering there. Unless there's any questions on that one specifically, I think we can go to EM, which is maybe the most interesting of the bunch. So this is just an ongoing effort to keep track of our electronic monitoring cases and further work with the judiciary in making sure this program is working effectively for the system. Basically, you can see a number of defendants were deemed ineligible for the program. I did dig a little bit deeper in these this morning. I went and looked in our case management software and figured out exactly why each person was deemed ineligible to the extent I could. I came up with basically 12 different defendants of 15 that were either denied or determined ineligible. So the numbers that I got here were the reports. 12 out of 15, the denial of eligibility was just based on having a prior warrant within the last 3 years. So I don't think that reflects very well on the program because, or what it's designed for rather, because oftentimes we'll know this going in. If somebody had been released previously on personal recognizance and then they were absent for 6 months, came in for their arraignment, and the magistrate judge said it has to be EM from now on, we already know that they'd had a bench warrant, and it's been sooner than the last 3 years. So we discussed this, I think, back in the February board meeting, that it might be time for probation to relook at this issue, and do they really want to determine that people are ineligible based on having a bench warrant in the last 3 years? I don't think it probably assists the court that much, because the court probably already knows it, and the court may be saying that EM is a good option for this person because of the bench warrant, not sort of in spite of it. All the courts, I think, will freely override probation on this issue, and there had been previous things that would make somebody ineligible for EM that have been tweaked over the years. Like it used to be that you had to have a GTA landline. That was unworkable for a lot of our clients that apply for a landline, and then it would be 2 or 3 months before it would be hooked up. These cases move fast sometimes, frequently, and the case might well be over before we could even accomplish just the basics of that. So that has changed over the years. Now a cell phone is adequate, and in real time probation can tell where this person is at all times. So it makes sense that if you can track where somebody physically is, having a landline telephone might not really be the assurance that is needed here. So that was my research on this one. Ken, I think we can move to the next slide. This was
Before
just
you get that, and we talked, I know that we had asked the presiding judge, and unfortunately he's not here now, and Judge Kwan to go back and look at the electronic monitoring guidelines. And I tend to agree with you that maybe, a prior warrant is not, should not necessarily in and of itself be grounds for denial or eligibility for electronic monitoring. The warrant, there may be different reasons for why there's an outstanding warrant, and I think a further examination, may provide better guidance on whether that person should or should not be eligible for it. So I think this is time for us to have this discussion again and to look at trying to expand the program. I know we've gotten a lot more people on EM. We have a limited budget on EM right now of 100 is what we've factored in for the current fiscal year and what we've put in for the next fiscal year. But the amount we save versus detention is significant. And so I think and we've been averaging about 88 defendants, if I recall from the last numbers that I've looked at. So I think we still have a little bit of room to add. And of course, there have been a number of defendants who have been on for a significant period, and we've asked to go back and re-examine whether they continue to need to be on EM. If, you know, for the duration, there have been no violations and no issues with them, because some of them have been on for, you know, lengthy periods, and I don't think they need to be. So, John, I'd like you to, if you can, we, you know, maybe get together with presiding and with Judge Kwan, and then also someone from the AG's office and probation, and I can facilitate that if we need to, so that we can get back and really pin down any adjustments we have to make to the existing policies.
Thanks for that, TJ. We're happy to help any way we can to make sure that this is successful. I think it has been a very good program for a lot of people. So we have some data here. We're happy to share it with the other stakeholders. And I would say also there's an overcrowding issue with the prison, and maybe it's time to get the director of DOC involved and see if we can come up with a post-judgment sentencing program that involves some level of EM as well. So thanks for that. And next one. This was an effort to answer some of the PJ's questions from the last board meeting relative to how many applications we're making for bail. I can tell you this is a very difficult thing for us to track in some respects because it's a pretty fluid process. But I can tell you what we do in just about every case. We get appointed to a case at the magistrate hearing. We almost always argue for release unless there's some reason not to, like they're held on a bunch of other cases and are getting credit. So we would always argue for a PR release or an appropriate release at the magistrate hearing. The following day, the case gets opened almost without exception, and we get an order, or we get an email after the assigned attorney notifying them that they've been appointed, as well as to their secretary and to the investigator that's going to be on every case. So from there, the investigator knows to go out and meet with this person. If they're in custody, they don't have to wait for the attorney's request. That's just a standing order. We've been doing that at least since COVID, that the investigators immediately go out and start working on release. They will meet with the person and see what they have, what's available to them. Do they have a place where they could reside? Do they have potential third parties? Do they have the things that they'll need, like a residence that's not part of the GURA system, to be on electronic monitoring? So they'll have that interview and then they'll submit it to the attorney. Frequently, the magistrate judge will have already told us what he needs to accomplish a release here. If it's not PR at the first instance, the magistrate judge may have told us that if you get me an address for this person where they can live by the next hearing, I will consider releasing them on PR. So frequently, we wouldn't need to file a motion because we know exactly what it's going to take to get their release. And some of the judges do it a little differently. Some of the trial judges will consider release, for instance, at every meeting with that defendant and tell them again exactly what it would need to accomplish release here, whether or not it's EM or TPC. So we tend not to file a lot of PR requests if we know exactly what the judge has told us they need outside of PR. We do file them, however, and these stats kind of reflect what they are, but it's a fluid process. So, I mean, that number is difficult to catch in any meaningful way. I can't have an order that says all our attorneys are going to file a PR motion in every single case, because the court may have told us that they're not going to do that orally, and told us what we need to get in place to get the release. And you know, if somebody's charged with a more serious offense, a CSC, a homicide, we know the likelihood of this being successful is going to be low. We should probably start looking at other ways to accomplish that release. But these are the numbers that we have for presentation at this meeting. With that,
just a quick look at the numbers suggests slightly more than half are being granted. Right, if I did that math right in my head, if you have 19 denied, and if you add up the total motions, there's about 40 total, 40 some. 40?
I think that's fair, and I'd have to drill down on what exactly these numbers mean, because in some instances, we may have gotten word from the magistrate about what they're requiring here, and then once it's in place, we file a motion to get a quick hearing. So these are the numbers.
Yeah, I count 41 motions filed and 19 of them being denied. So at least half of the pretrial motions for release, post detention are being granted. So, all right.
Unless there's any other questions, that'll do it for PDSC.
Okay. All right. Can I hear now from APD's managing attorney?
Good afternoon, Your Honor. We did file our stats for the up to May of 2025. So far for May 2025, we got 50 cases. We did add the bail motions for release. This is what Judge Lamarena wanted to see. And the same reasoning that John had just put together, that it really depends on the type of case that gets filed, whether or not we filed a bail motion right away or whatever happens, because again, we ask for release at the magistrate's hearing, and if they're not going to get released, then what does it take to get them released, either EMP? It just depends on the type of case it is and whether or not the client's being held on something else once they're in custody, because they'll get a violation and inevitably they'll get revoked on certain things. But anyway, so those are the numbers are on track as well. I think it's a good idea that we do go back to review the EMP rules that have been in place, and so now that we have the data to show what needs to be done that can help get more of our clients on the EMP. I think it would be a good idea to go and have another meeting to figure it out and get more to get a clearer understanding of how it works and what doesn't work. So please count me in on that working meeting, Justice Torres. If there's not anything else, I know we have new business to look at, so I'll defer. If anybody has any questions, I'll be happy to answer. Thank you.
All right. Any questions from Annie? It looks like your bail motions are pretty successful if you're filing. Only 2 of the 23 that were filed were denied.
Yeah, I was a little surprised about that too. It's just one of those things. Thank you, Your Honor.
All right. Thank you. And CLC managing attorney?
Yes, good afternoon, Your Honor, and everybody. So CLC, we've been quite busy. Of course, as part of the 50th Jubilee, we've started our mobile clinics where we're going out into the community and actually doing the services at our senior centers. So that started this month, and it'll be for the next month. We're working with the consulate offices as well as the archdiocese and the clinics that we service, so we can get mobile clinics done in those areas as well. We're also at this point, as part of the improving access to justice, like Your Honor was pushing in your state of the judiciary, we're also working on a QR code so that our services can be accessed online through the QR code where they can do the intake forms. That's something we're trying to work on right now. We're also planning to, I need to discuss with our EJC Advisory Commission, but we're planning on utilizing some of our funds from both EJC as well as COC to conduct a training that I'm going to be working with the Guam Bar on, because this one's more of a civil legal needs and program priority seminar that we're going to have, where we have our consumers as well as key stakeholders that are invited, so we can discuss not only it's mainly geared towards elder justice, as far as like elder abuse and all that stuff. We want to provide them with training on materials like what is elder abuse. We're going to train them on what is on the new like TOD that just passed the statute and their options on estate planning. So it's more like an educational as well as we're going to have a lunch session on program priorities to see what the needs are in the community so we can develop an annual report for the Chief Justice as well as the Guam Bar and civil legal needs. And we're looking at sometime in September once I talk to the EJC Advisory Commission on that. And then we're going to be requesting to look at expansion of services only because Guam Legal Services has been affected by their federal grants. And Micronesian Legal Services, I contacted them and they are also affected. They lost 10%. They're anticipating another loss of 30%. And so we'd want to expand into at least areas that we can assist the indigent on uncontested matters, like divorce and custody, where they're income eligible. But that's something, again, we'll be bringing forth to the board as part of our movement because we do want to expand services. We did get donations on our office space, and that's why we're now discussing training. We got donations from Ernest & Young, so I wanted to just acknowledge and thank John Onadera, Lethia, and Kavika. They gave us cubicle spaces, which we were going to buy to build up cubicles, but they donated it to us. And so we have that now in our office. It's set up. And today is the first time we ever received a $100 donation from a client. We were told by Division of Senior Citizens last year to post it on our webpage and on our walls. And he actually came in and donated $100. That's going to be used towards elders. So that's what we've been doing lately. We provided stats. We're fixing up our stats. We're going to revamp the stats so we can capture a better picture and provide a better picture as to the different programs that are being done in the office and the stats coming out of that program. So the mobile clinic will have its own stats and it'll identify what services were offered on the field where they actually get all the services done there. And then we're partnering up with like Rev and Tax. So we can try to see how we can partner up with them and see if they can work with us on getting like ID cards for the indigents or the clients we work with, like the elderly that have expired identification cards. And that's basically where we're at right now, Your Honor.
Any questions for Carol? All right, we'll monitor the GL Guam Legal Services situation as well as the request that you'll have for expansion of services. Obviously, it may depend. It looks like we will have another board meeting in July. We just got word that the legislative session will be at the end of July, and so the new board will have to be constituted once assuming the law passes, and then get signed into law is what the transitional language is, I believe, for the new board. And then that board will address the issues of the expansion of services and other items. All right, if there's no questions for Carol, we'll now go to the next item on the agenda, which is under new business, and there's a proposed resolution relative to the recommendations for the continuity of operations on the PAP. And I looked at the resolution, and I propose that we make a change to the resolution because it references the Guam Judiciary's miscellaneous rules and forms. But of course, when Bill 9738, which has been introduced by Senator Taitigui and Speaker Blas, assuming that it passes, and we have no reason to believe it won't get the support for passage, the new board will be constituted, and it makes sense to have those rules be Public Defender Service Corporation documents and not cross-reference back to the existing rules of the judiciary. And so I have some proposed language that I would like to recommend that we put in the resolved clauses. If you can go down to the bottom. Because right now it just cross-referenced the existing rules and procedures and keeping them in place. And we can still reference those rules and forms as a guide and actually have those rules and forms almost adopted identically But I think, there needs to be some language changes, even if it's just for semantics, as well as the fact that it's under PDSC and not under the judiciary anymore, assuming that passes. And so I did send proposed language around to the board members as well as to the executive director, acting executive director, and the administrative director. And what I'm proposing is that the now therefore be it resolved clause be changed to that the management of the Guam Public Defender Service Corporation shall develop and prepare recommendations governing the administration of the private attorney panel division no later than August 1st, 2025, for timely review and adoption by the newly appointed Board of Trustees following the enactment of Bill number 97-38 LS. And then the second resolved clause be it further resolved that such recommendations shall be sufficiently detailed to support action by the new board upon its convening, and shall at a minimum include the following: A, qualifications for appointment of the private attorneys to the private attorney panel division; B, procedures for the assignment of cases; C, a fee structure including compensation caps and processes for requesting exceptions; D, record keeping and reporting requirements; E, appointment of investigators, experts, and paralegals; F, private attorney panel division applications; and G, financial declarations. And so all of those are pretty much contained in the JOG miscellaneous rules and forms, but I'd like to see it done as a public defender, modified accordingly, and then put in a single packet so it's available for the new board to act, even with those as the recommendations from management. So that is my proposal to that resolution. And can I entertain a second for purposes of discussion?
Second.
All right. Thank you, Trustee Kanata. Is there any discussion on this proposal by anyone? I mean, it just seems to make sense that we do it this way and put it in. And I appreciate the effort by the with the first draft of the resolution, but I think rather than cross-referencing, going back to the rules, those rules aren't going to be in effect anymore once these new ones are done. So if we can work on, we can vote on this resolution if there's no, it's been moved and seconded. If there's no objection, I'll call for the vote now on the resolution as amended with the two new resolved clauses. All those in favor say aye.
Aye.
Aye. There being no objection, it's approved. So if we can then start working on that, and we'd be happy to help as well. John and Shane, Diane and Sarah and Danielle as well, if the judiciary can help make sure we get everything covered and that we have the new proposed recommendations ready for action by the newly constituted board, assuming that the legislation passes in the session in July and signed by the governor, hopefully shortly thereafter. All right. Is there anything else now on the agenda? Anything under new business? Any communications? Shane, or any public discussion? Any items for public discussion?
Nothing at this time, Your Honor. We don't have anything on the agenda.
All right. So our next meeting is scheduled for July 22nd, which is the day after Liberation.
And that would be our last meeting, right, sir?
Presumably, if the legislature acts and it is and passes the bill, then the governor, and assuming the governor signs it, the new board would be constituted immediately upon the enactment of the legislation. And but the new board has to be appointed. There are certain appointees that will come, so presumably they'll get appointed quickly. by the respective appointing agencies or authorities. And if they do, then that could be our last meeting, yes.
Okay, so we don't have to turn in a letter of, like resignation or anything like that? Yeah.
No,
Okay.
no. John, is there anything that you wanted to talk about, because this is our last meeting before the 50th anniversary, and I noticed we didn't have anything on the agenda to talk about that, and what's going on with regards to the planning, the RSVPs. I know a number of judges have indicated they didn't get any notice or invitations for it.
CJ, we'll have to look at we'll have to look carefully at our invitation list and make sure everybody that's supposed to be invited got the letter. I know
not to say that I'm pushing you to invite them if you didn't want to, but they just mentioned it. They just mentioned they were not invited, or some of them were, and and I want to make sure that. Yeah.
We'll take a look at our list again, make sure. I know that the Supreme Court should have all gotten invitations, and a lot of other stakeholders. We're I think in the final draft of our agenda for it. I know for our panel, invitations went out last week and we're getting confirmation notices in. So I would hope maybe in the next week or so, we can meet with our moderator and our panelists and just go over the subjects that we're going to talk about and make sure everybody's comfortable with the subject matter and starts thinking about how they can weigh in on those different areas. So it's very much a work in progress, but we're looking forward to it.
All right. And then I assume you've coordinated with the legislature, with Senator Titagui's office regarding any resolutions that might be done recognizing the 50th, as well as with the governor's office. And
Yes.
And actually I'll ask that we put get a resolution from the Judicial Council as well.
Oh, terrific.
Thank you, CJ. Yes, we did coordinate. We are in communication with Senator Teddy's office and the front office as well.
Okay. All right. Is there anything else for the order of business? If not, can I entertain a motion to adjourn?
Motion to adjourn, please.
All right, it's been a motion. Any objection? No
None.
objections. All right, we'll now stand adjourned until our next meeting. Thank you, everyone.
Okay, be safe,
Thank you.
everyone.
Bye.
Bye.
Bye-bye.